up a number of committees. These committees had seasoned technocrats as chairman of the committee, and eventually when he emerged as governor, this was his very first set of commissioners. For justice, he had Professor Yemi Osinbajo, SAN. And so today, the development that Lagos has recorded, as it were, in terms of the judiciary, is owed to that arrangement. And you recall that the reason why the Attorney General also succeeded was because he had a governor who believed in administration of justice. So when we talk about technology, we're looking at such people.
But when you say that the time that she has is short,
yes.
How long does it take? How long are you looking at to get the ball rolling?
No, because you see, for the kind of reform that we're looking at, you need to have somebody who will be there for quite a while. If you start it and you have less than 3 years to execute these policies, what is the guarantee that the next person will be able to push through? So far, she's done well. How far she can go, we can only sit back and hope that whoever takes over from her will continue with the reform. Mind you, this reform started after Justice Alpha Belgore took over from Justice Kutigi. Now, it's a process. And you now have someone who also believes that, look, we will not allow the judicial ship to sink. We must ensure that it stays afloat. And so essentially what she's doing is like moving against the tide. You have what we call institutional corruption. You also have politicians who are also out to also frustrate the judiciary from living up to his billings and the expectation of the larger society.
But again, so, the way they say, sorry to comment there, they say it takes two to tango. So if the judicial officers don't actually fall for the prey of the politicians, we don't think that we'll be in this dire situation we are in already.
Not really. Some of them are actually helpless. A situation where...
Helpless?
Yes, and I will explain. Sometime back, I said here that there are a number of factors that would bring about corruption, for instance, in the judiciary. A number of factors, not necessarily financial inducement. Sometimes it could be as a result of social conspiration, political conspiration, family affinity, and such like. Now, as a judicial officer, you're expected to remain impervious to such influences. You're expected to stand aloof. You're expected to be insensitive. You're expected not to be swayed by sentiments and by emotion. But oftentimes you find that this is not so. They are also human beings. But politicians have also come in. If, for instance, I'm seeking for judicial appointment, and perhaps you're close to the powers that be, and you influence my appointment, we can't overrule that possibility. You influence my appointment. I will owe you some favor somehow. Yeah, and that has nothing to do with corruption. That has nothing to do with financial inducement.
But they've always been humans. I mean, right from the time where judges used to seclude themselves, you won't see them at public functions. They were always human.
The process then was different.
What changed?
The process then was different. You see, Nigeria has changed over time. And somebody once said it is economic downturn that has changed a number of things. The way we think, the way we behave, the way we do things. More so, also our military background. If you notice, we're not really civil, the way we do things in this country. Sometimes I look at the way we drive and I'm amazed that are we really human beings? We are so insensitive, we're so mean to each other, we're so nasty and so wicked. So when you look at all of that, this whole thing started, let's say about 20, 30 years back, so to speak. I remember growing up in Lagos. You could walk freely in some areas. You could ask your kids to go to your neighbor's house and sit down. But now that can happen. I grew up in a neighborhood where we used to interact with each other. I would leave my house, go to my neighbor's house, we sit down for hours just chatting and walk back to there. Sometimes as late as 10 o'clock, we're still on the street, playing with each other, enjoying each other's company. Your parents are not around. You can afford to leave your children with your next door neighbor. Your next door neighbor is also some sort of pressure, so to speak, to ensure that he or she is responsible for your own upkeep as well. But that can happen now. So a number of things have changed.
So what kind of process was it like then? I agree that the society has changed, but the kind of process that the judicial officers went through at that point in time, Chamberlain talked about that you would hardly see a judicial officer maybe in public places.
Then appointment was more of merit. We didn't have the kind of political consideration and other factors that are now militating against us and in terms of appointment. Then if you're going to be appointed, it will be based on who you are. It will be based on what you can deliver. It will be based on your pedigree and all of that. But now a number of constraints. There's so many other things. I won't say that we didn't also have the quota system, for instance. It's always been there. But appointments oftentimes were made on merit. If you don't deserve to be given that appointment, you will not get there. If you go back in time to the Supreme Court of then, or Court of Appeal of then, or the High Court of, you find seasoned judges. You find men of sterling quality. You find people of integrity occupying the office. You have some of them now that are there, but the appointment right now, for a lot of us, we feel that there's a need to also reform it.
Can't we link all of this to training, the quality of training? Is it getting better or worse? Because even if you have to consider certain things before you appoint persons, they go through the same training, don't they? The
training has always been there. It hasn't really changed. You have the National Judicial Institute that is responsible to train judges. Yeah. They have a curricula, as it were. They have seasoned technocrats, retired judges, judges of old, and a number of other things. But it has nothing to do with the final output or the final outcome of the training. This is individualistic. It has to do with the individual person occupying the office who has gone through the training. You can't, oftentimes we say that you cannot legislate conduct. It has to do with you as a person. You go through the training, but that will not, sometimes they say you go to the university, as the university going through you, or did you just simply pass out from the university and then you have a university degree?
I think one of the reasons why Chamberlain brought that out is because the complaint is also in the quality of judgments. And some of your colleagues have said that there is little or no erudition in some of the judgments that we're seeing these days.
Yes, they're correct. But like we keep saying, it has nothing to do with the training. It has to do with the individual. If you're committed, today there are a number of judges that we celebrate. I know a particular judge who went through the magistracy, and today she's in the Supreme Court. Now, the period she was a magistrate, sitting as a magistrate, if you appear before her, you could liken her court to the High Court. Because when we talk about course of records, we're looking at, essentially at the High Court. Now, if you go to her court, you find her taking legal arguments, writing judgments, well-considered judgment, referring to cases, unlike some other magistrates who would just simply give a ruling, what they call bench ruling, and it does not even make sense to you. Now, if you find such a person go through the mill and then eventually becomes a Supreme Court justice, what then happens? So what you're seeing is an output, a projection of what some of these judges have gone through to get to where they are. So it has nothing to do with the training, it has nothing to do with the orientation, it has to do with the individual person.
You know, it brings to mind again checks and balance, which we thought the NJC would have been carrying out. But again, the way and manner with which we bring petitions before the NJC, and some saying that you must put your name on such petitions before they're considered, don't you think that we should also consider that and also consider anonymous petitions? Because some lawyers wouldn't even dare talk about some misnomer they have experienced in the law court.
You see, the danger in encouraging anonymous petitions. I remember the judge who just retired recently from the Federal High Court, and she said something. If we continue to encourage petitions, judicial officers will be handicapped, judicial officers will be intimidated, judicial officers will be caged and hindered from performing their judicial function. Now, the essence of disclosing your identity and your name is that when a petition comes, under our law, you are given an opportunity to defend yourself. So you're confronted with your petitioner. The petitioner comes forward. Now, if a petition cannot be defended, under the criminal system, there must be a complainant. There must be an identifiable complainant. And if you're certain that whatever allegation you're putting forward by way of a petition can be defended, why anonymous? If you feel that the judge is corrupt and you can substantiate this corruption, why write an anonymous petition? Why can't you put your name? You see, until we learn to do things like that, this country will not move forward.
Well, speaking about improving the quality of judgments and the confidence in the judiciary, what about the way judges are appointed? Isn't that something that should be reviewed also?
It was part of what I talked about a few minutes ago, that we need to revisit it. We need to go back to the era of merit. You don't just appoint just anybody to the bench. There are a number of constraints, a number of factors that have to be considered. person's antecedents, although we have a system in place, checks and balances. If, for instance, Mukwe is to be appointed as a judge, and I have issues about Mukwe, I'm entitled to write a petition concerning what, and then she'll be invited to defend herself. And if she's able to